maybe I should also just indicate to the meeting that the Deputy Minister for Justice has given us an apology for the meeting. Members will also recall that it was on pretty short notice that we arranged this meeting. But given the fact that we're dealing with regulations, we thought that perhaps it would be prudent for us to continue with the process. The amendments to the regulations are pretty technical. But anyway, I think from honorable members, there's only been an apology from Honorable Fisser. And I'm not sure, Gershwin, if you're on the platform, if there was any other apology.
No, Chairperson.
Okay, that's it, honorable members. In terms of registered apologies, okay, but let me just indicate, okay, I see Nkosi has not yet joined the platform. Maybe Dodovo, maybe if you could, sorry, Gershwin, if you could maybe just follow up with Nkosi. Honourable members and the delegation from welcome once again to this meeting. This is our first committee meeting since the devastating rainfall and floods that affected both KwaZulu-Natal and some parts of the Eastern Cape, which also led to the loss of lives, as well as massive destruction to human settlements and infrastructure. And I think as a committee, our humblest condolences go out to the families that have lost loved ones and those who were injured. We wish them a speedy recovery. But let me also reiterate the plea by Parliament for urgent interventions to save lives and livelihoods and the mobilization of resources to speedily address this destruction. Members, as I indicated earlier, that today we'll be dealing with the amended regulations in terms of the Child Justice Act 2008, which members will recall, as a committee, we made amendments to this act in 2019. And the amended regulations in effect are aligned to the amended act. In terms of the Child Justice Act, Section 97, subsection 1, it empowers the minister to make regulations after consultation, where appropriate, with the cabinet members responsible for social development, safety and security, education, correctional services, and health. And these regulations were published it was published in the government notice R251 of the 31st of March 2010, and amended by government notice number R1337 of the 1st of December 2017. In terms of section 97, subsection 2 of the regulations, 97 subsection 2 of the Child Justice Act, the regulations must be tabled in Parliament for approval, and that's why, honourable members, it's serving before us today. Without further ado, I just want to confirm we have Honourable Mthethwa and Nkosi who have also joined the meeting. Welcome, honourable members. I don't expect this meeting, honourable members, to also take very long, but let me hand over then to the department. I think it's Ms. Baden who is with us, who can perhaps she could just indicate who is here and who will be doing the presentation. Ms. Baden.
Good morning, Chair, and good morning, honourable members of the committee. Ms. Van der Walt is going to do the presentation on behalf of the department. She's from our Legislative Development Unit. Thank you, Chair.
Okay.
Good morning. Yes, sorry. Good morning, Honourable Chair and members of the committee. And I really want to say thank you for giving us this opportunity to present to you, because we are really pressed for time and we really want to get this commencing as soon as possible. So let me see if I can share my screen with the, just see, I want to get that presentation. There we are. Can you all see that?
I don't see anything. Honourable members, can you see anything?
It's on now on my screen. Let me just try again. Technology and I am not the best of people. Oh, okay, great stuff. Thank you so much. Thank you so much. Okay, this we have seen now. It is the briefing today. Next screen, please. Thank you. And as you already know, the Child Justice Act establishes a criminal justice system for children who are in conflict with the law, and that was amended by the Child Justice Amendment Act 2019, which was assented to by the President on 26 May 2020. So it's already a couple of times. Now, you all know what's the amendments about, so I won't waste the committee's time with that, but I just want to highlight the amendments that really pertains to the amendment of regulations. And first, it was the definition of appropriate adult that was amended in the Amendment Act to appropriate person. So the adult was just substituted with person, and that necessitated a lot of amendments in the regulations. Then the second amendment that pertains to the regulations was the increase of the minimum age from 10 to 12 years. So that also had a lot of amendments that we had to do. And then the third one was that the criminal capacity of the child will only be addressed during a plea and trial in a child justice court, and not during the preliminary inquiry and for diversion purposes. Now, all that changed here. It was normally the inquiry magistrate or the child justice court, and inquiry magistrate was taken out, so it's only just the child justice court. Next screen, please. Okay, already, as you know, Section 97 empowers the Minister to make regulations, and in terms of 97.2, it must be tabled in Parliament for approval. Now, these regulations or draft regulations were, the Portfolio Committee was briefed on that on 16 March, and they approved of this. So now it serves before you. Next slide, please. Okay, the content of the amendment regulations. Clause 1 is only the definition clause that says where all the regulations are and the amendments. Now, clause 2 contains the general amendment of the regulations and provides for the substitution for the expression 10 years of the expression 12 years, wherever that expression appears in the regulations. The substitution for the expression appropriate adult of the expression appropriate person. And just for interest's sake, is that there's a couple of amendments. The amendments with regards to appropriate person appears about 20 times, and the expression 10 years also a couple of times. So that's why we did only do the general provision. Now, amendment of Regulation 13, here we are amending it by removing the provision that the inquiry magistrate may issue an order and just substitute it with the provision that the Child Justice Court may order. And providing now, we also inserted the sub-regulation 2, which says providing that Form 2 must be submitted to the person who must conduct the evaluation together with any documents handed in at the preliminary inquiry or in the Child Justice Court. And this is the insertion that the Department of Health wanted, including the charge sheet and the probation officer's assessment report. The next slide, please. All right, then the Department of Health also requested an amendment to regulation. Let me just get to that regulation. Also regulation 13, it's still the same regulation that's been amended. And here is an addition of the following sub-regulation 5. The Director General Health must annually compile and keep a list of private psychiatrists and clinical counseling and educational psychologists who are prepared to conduct the evaluation in respect of a child's criminal capacity in terms of Section 11.3 of the Act, and must provide the Director General Department of Justice and Constitutional Development with a copy thereof for distribution to the registrars of the High Court and all the clerks of the magistrate courts. Next slide, please. Now, as a result of these amendments to the regulations, we also had to amend the forms 1 and 2 of the regulation to bring it in line. Form 1 is amended to make it more user-friendly and to provide for the referral of a child under the age of 12 years as opposed to 10 years. Form 2 is amended to remove the reference to an inquiry magistrate in line with the amendments to Regulation 13. Form 2 is also amended in order to ensure that the charge sheet and the probation officer's report are submitted to the person who is to conduct the criminal capacity of the child in line with the amendments to Regulation 13. Next slide, please. Okay, we also, consulted widely with this draft regulations. It was in the committee, the Intersectoral Committee for Child Justice. And there you can see it was the Directors General of Justice and Constitutional Development, who's the chairperson, Social Development, Basic Education, Health, the NDPP, the National Commissioner of the South African Police Service, and Correctional Services. They form part of this committee. As required by Section 97 of the Act, consultation with the Cabinet members responsible for social development, safety and security education, correctional services and health took place. And consultation also took place on a continued basis with senior officials of the relevant departments. Next slide, please. The Department of Correctional Service was in agreement, had no further comments to offer. The Department of Health, we included what they wanted. All three of them. You'll see point 2, regulations to specify the annual revision of tariffs offered for private psychiatrists and psychologists, but this is dealt with in the notice issued by the Minister of Justice and Correctional Services in terms of Section 97.3 of the Act. The charge sheet, we also did that in Regulation 32. Next slide, please. Social development was in agreement and had no further comments. Basic education also in agreement and no further comments. National Prosecuting Authority in agreement and no further comments. Office of the Chief Justice, they didn't submit any comments. Zeta Center for Child Law, they were in agreement. Next slide, please. SAPS in agreement and no further comments. Legal Aid Board in agreement and no further comments. Teddy Bear Clinic in agreement. Cape Winelands, Overberg Region in agreement. Next slide, please. Okay, there we said Section 97 of the Act provides that the regulations referred to in subsection 97.1 must be tabled in Parliament for approval. Next slide, please. The Amendment Act is also not into operation, and we will put it on a into operation on a date to be determined. And it is envisaged that the draft regulations will come into operation on the same date. We don't have a date as yet, but we envisage that we might, or that we want to put it into operation on 30 June, together with the SORMA regulations and the commencement of that Amendment Act. Next slide, and that is that. We say thank you, and any further questions, we will gladly answer. Thank you.
Thank you very much, Ms. van der Walt and Ms. Badenhorst, for that presentation. Honourable members, I'm going to just open it up if you have any comments or questions that you would want to ask, questions of clarity, bearing in mind that these regulations give effect to amendment that we made to the Child Justice Amendment Act. Honourable members, if you can maybe give me an indication by a raise of hands. I think the presentation was very clear. And if I recall correctly, there are no questions and no comments. Then maybe just from my side, while the presentation does indicate the in-depth consultation that took place, and I know there's been no comment or from various stakeholders and or support. But are there any other remaining concerns from the side of the department in respect of the amendments? Perhaps if we could respond to that, Ms. Badenhorst or Ms. van der Walt.
Okay, there's no other amendments to the child justice regulations. What we have presented, that is the only amendments at this stage. So no other amendments were prepared or submitted for comments.
Okay, thank you very much. I think on members, one more opportunity. If not, then I take it that the presentation was pretty clear. But maybe let me just indicate that these regulations are also important in terms of ensuring that children in conflict with the law are treated fairly at all times. And as a committee, let me also just thank the department once again for your presentation and the information you provided to us pertaining to the regulations. We note on your slide 13 or 14, I'm not sure, where it is envisaged that the Amendment Act as well as the regulation should come into operation by the 30th of June 2022. And I think this committee will take this time frame into consideration. And yeah, I think thank you very much, honourable members, for your attendance. Thank you to the department for also briefing us on short notice. And I think in our future deliberation on members, we will then deal with what is expected of us in terms of Section 97, Subsection 2 of the Child Justice Act.
Chair, my hands is up.
With regard to, Honourable Mthethwa. Apologies, yes. I moved, so I thought members didn't raise their hands. Please go ahead.
Sorry, Chair, I didn't want to interrupt you. Thank you very much, Chair. I've noticed that in terms of one of your legal terms, where it was written magistrate, why do you have to change from magistrate? Because magistrate, we believe that is the lowest area of intervention in terms of the law. I've noticed you mentioned that you needed to amend that word magistrate. Can I be clarified, Chair?
I think it was removal, but Ms. van der Walt or Ms. Badenhorst, can you clarify that?
Okay, thank you very much for that question. The Amendment Act removed inquiry magistrate. from a couple of provisions and just had it child justice court. So that is what we did. We brought that in line with the regulations. Maybe Dr. Badenhorst has more information as to why inquiry magistrate was removed and it's only child justice court, but that's the reason why we amended the regulations as such. Thank you.
Ms. Badenhorst?
Thank you, Honourable Chair. Yes, no, what happened with the amendment in the Amendment Act was that criminal capacity was considered, and there are two processes in terms of the Child Justice Act. You have a preliminary inquiry, and then you have a trial, a plea and trial in the Child Justice Court. So in terms of the amendments, before the amendments, criminal capacity could be considered during the preliminary inquiry process. So the Act then referred to the preliminary magistrate must consider. So when we took out the consideration of the criminal capacity during the preliminary inquiry, we had to take out the wording of inquiry magistrate in the subsequent sections to follow the amendments of the Act. So basically, we didn't change or we didn't remove the word, the name magistrate or inquiry magistrate. We just took out the consideration of criminal capacity during the preliminary inquiry process. So that then forced us to take out the wording inquiry magistrate out of the regulations, because criminal capacity is no longer being considered during the preliminary inquiry process. So then we only refer to the Child Justice Court, which is then the magistrate or the presiding officer in the Child Justice Court. So we didn't remove the name as such or change the name. It's just the process. And the Act refers to inquiry magistrate. I'm not sure if that's clear.
Okay, now thank you very much. Honourable Mthethwa, are you covered?
Yes, I'm clarified. Thank you very much, Chair.
I think we also dealt with some of these issues quite extensively when we dealt with the Amendment Act as well. We might have forgotten because we did this in 2019 as well. But thank you very much, honourable members, and thank you very much to the department. I think I tried to conclude when Honourable Mthethwa came on, but I don't want to repeat myself. And let me then also declare this meeting closed. Thank you very much.
Thank you very much, Chair.
Siyabonga, Chair.
Thank you, Sheikh.
Thank you.
Slik.
Yes,
Yes, Lid.
yes, Andame.
Utheni mfundi?
Ukhona kunjani?
Kamthethwa afuna simphumele.
Mnyambozi.
Ya afuna simphumele kaloku. Atubalekile nje udle phansi.